Okay, so we're getting pretty close here. So I think what we're going to do is get this conference going. We've done some sound checks, so I can hear everyone pretty well. Again, if somebody comes on during the middle of the call and we can't hear them so well, we might have to sort of take some time out and just coach them a little bit. But whenever you're not on the phone or you're not making a asking a question or something like that, we ask you to mute your line. It just sort of helps the people asking questions, just sort of answer them. I know that someone's just come on the line now. Can you just introduce yourself there?
Hi, it's James.
James, in South Africa?
Yeah.
Okay, great. I was just mentioning to some of the others that it's a ridiculously early time of the morning over there. So
3 a.m.
Right, so we're going to try and get this thing going on time here and give you a chance to answer your questions right up the front there. But in the meantime, I'm just going to, we do have the webinar started, so you can log on via freeconferencecall.com. We're going to show some just different websites and just sort of explain a couple of different things. And we'll just sort of take it from there. I'll introduce our guests, and if there's any audio problems, we'll try and rectify them as quickly as possible. So I'm going to introduce myself. My name's Nimmers Stern. I'm the founder of Stern Deeds, which is a management and production services company. We're based here in Brooklyn, New York. We're trying to help people make that transition from wherever they're doing what they're doing right now into the US so they can try and apply their trade over here. We host these webinars and different information nights through our meetup group, which is called Creatives International, and we've got the post right up there. And we also have another group, Creatives International LA, which we've also posted this event on because it's essentially a virtual event. Anyone can sort of log in. And we also have the phone number so people around the world can also dial in. So from time to time we'll do events like this to try and give people information and give them access to attorneys who are here in the US, and they can ask real questions and get some really solid information. Before we get started with this this webinar, I do want to make a disclaimer about all this, that this is not a substitute for legal advice, and we don't want anyone sort of taking this information away and saying, oh, so-and-so told me it's written in gold. With every one of these visa applications of any kind, there's a lot of specific information, and we do ask everyone to seek legal advice and get advice pertaining to you. So for the most part, we're going to try and keep this somewhat general. You'll have specifics about your case, but when we're giving advice, I just want to be clear with everyone that it's not a substitute for something outside of that. Having said that, I'd like to introduce our speakers for today. They happen to be in our same office building here in Brooklyn, Williamsburg, Brooklyn. We bumped into them earlier in the year, and it turns out they've been doing some fantastic work, helping amazing clients of all different skill levels. And we were looking for an event to partner up with them. They're on the line now, so I'm going to ask Dana and Sarah to sort of introduce themselves here and sort of tell us a little bit about who they are.
Thanks, Nimmers. So this is Sarah here. I sound a lot like Dana, so if you can't tell us apart, that's fine. We are both business immigration lawyers. We have about 10 years of business immigration experience. We started our career working at the same large business immigration law firm and recently set up our own practice in Williamsburg earlier this year. And as Nimmers said, we specialize in all types of work visas, but really do like working with entrepreneurs, startups, creatives, and that's really where the focus of our practice is. So we have lots of O-1 experience to share.
Excellent, cool. And do you want to pass over now to your partner?
So this is Dana, everyone, and as Sarah already warned, we sound similar, particularly on the phone, but we are interchangeable. So I second everything she said, and I'll add to that the O-1 visa is absolutely a favorite visa category of both of ours. partly because it is typically available all year long, which is not the case with many or some of the other common visa types. And it's also really great to sort of share someone's backstory and narrative in a way that sets them out as extraordinary before the Immigration Service. So just adding to what Sarah said, it's not only something we have a lot of experience in, it's something we really enjoy doing and working with our clients on.
Now the O-1 is a very broad visa. I mean, it's affectionately known as the artist visa. But, my understanding is it really does run the gamut there. That, I don't want to say any profession, but anyone who proves themselves to be extraordinary is eligible for this. Is that true?
That's correct. It's applicable to almost any industry: science, arts, education, business, athletics, and it's really just for people who have who stand out at the top of their field. There's the O-1A, which is more traditionally used for for business and science, and then the O-1B is more for people in creative spheres. And there actually are different sets of criteria for the different types of visas. The O-1A criteria are slightly higher in terms of the threshold than the O-1B. They require you to show that you're really at the top 1 to 2% of your field, whereas the O-1B require you to show that you have a level of distinction in your field, and the actual specific criteria for each of those are similar, but they're slightly different. So it does apply to almost any industry, and there are different sets of criteria, whether you're focusing more on business or arts in terms of your profession.
Okay, cool. So, look, I think, we may as well jump straight into this and start firing away questions. And then, as different topics come up, we can sort of dig into each one of them a little bit more. But I'm going to throw it over for the first question to James in South Africa. I know he's logged on and he's been working with us for a little while now. James, are you on the line there? Can you do you want to pick it up? Just introduce yourself, to tell us who you are, what your situation is.
Sorry, I'm a bit tired. I was waking up. My name is James Carroll. I've worked as a producer and editor in South Africa, and I've worked in different countries across the world as well. And I'm currently a senior producer on a very long-running weekly news show called Carte Blanche, where I produce and I edit my own insert. I've been in the process of going through this for about a year and a half, and the question that's come up is I also hold an Irish passport. So is it better to apply my Irish passport or my South African passport?
So there's no benefit to either. There are certain passports that have specific immigration benefits tied to them. Australian, Canadian, Mexican, Chilean, and Singapore are the five that are I think those are the only five right now. There was some talk of potentially a visa agreement with Ireland, but nothing has expired as of yet. So right now, South Africa and Ireland would both be treated, relatively equally in terms of if you wanted to apply for a visa and an O-1, both you would get no preferential treatment from one passport versus the other.
Okay. And could I potentially travel to the States on my Irish while still applying on my South African? The reason why I ask is because the news show that I'm on about 2 days ago asked me if it's possible for me to go to LA for a couple of weeks to do a news insert there. But I mean, I don't want to hold up the process of my application any longer.
Sorry, you cut out a little bit there. You want to come to LA for 2 days?
Yeah. So the show I'm on wants me to travel to LA in a couple of weeks. But I also want to start my application process. So could I start my application process on my South African passport but travel on my Irish?
So this is Dana.
Go ahead, Dana.
I'll take this one. So what you shouldn't do is leave one passport with a consulate or embassy while a visa stamp is being issued and then travel to the States on another passport. They don't like that. They want you to stay within their jurisdiction while they are issuing you a visa stamp. But if you're talking about generally starting a visa application process, preparing an O-1 to be filed with the intention of getting that stamp in your South African passport, there's nothing to prevent you from traveling to the U.S. while that application is in process.
Okay, great. Yeah.
Okay, cool. So, James, did you have any other questions then?
Not right now.
Okay, cool. So what I'm going to do is we have a couple of questions that were mailed into us. So I'm going to just sort of head off with a couple more of them. And then if you have more questions at the end, we can sort of circle back around for another general sort of Q&A. Is that all right? Yeah.
Thanks.
Okay, so I have a question here over email from Jenny from Guatemala. She says, I'm a gynecologist and an obstetrician here in Guatemala City. I have my own clinic. I deliver babies at the hospital almost every week. Am I eligible to work in the U.S.? Is there an O-1 for my situation?
So it sounds like she does work in a profession and she has a professional degree, so there could be several visas available to her to work in the U.S. For the O-1 to work in a profession like medicine, you do have to show a pretty high level of achievement in your field. You want things like, being published in medical journals, having, been a part of, well-received studies and things like that. So you're going to need a lot of documentation to show that you are at the top levels of your field. So again, it's a very circumstance-specific question, but to be eligible for the O-1, you would have to show something like that. There are other potential visas available. For example, the H-1B would just, it requires that you have a degree related to the field in which you'll be working in. So if she has a medical degree and will be working in medicine, that certainly would be a fit. But so generally, yes, if you are someone coming to work in your profession, there are visas available. Which visa is the best fit is a very circumstance-specific determination.
Okay.
So to add to that, the short answer to the question is there's no ban or prohibition for someone under that set of facts to apply for or qualify for a visa. What Sarah's talking about is that sort of second layer of review. Yes, there are options for you, but what's the best one and what do you readily qualify for? And that's where it gets into a circumstance and fact-specific analysis. For the O-1, checking that she does rise to the level of someone at the very top of her field with those publications, et cetera. And then there's another big component of most visa types, which is also showing that you have an opportunity in the U.S. to work in your field. And in some instances that may be for a company that you're starting. Employment in your field, the field that we're going to say you're extraordinary in.
I think we just lost you there for a second. I'm sorry, I'm just going to have you repeat those last couple of sentences because I think the line just dropped out.
So I'm not sure how much we missed, but the other thing besides looking at someone's CV and their direct qualifications is showing that they have an offer of employment in the field that they are extraordinary in or qualified to work in, and sometimes that's a bigger hurdle.
Right. Yeah, but there's no specific. I think the question is there's no specific visa for doctors. A doctor or a gynecologist, they fall into the same category as everybody else as far as an H-1B or an O-1 or something like that.
Not necessarily. There are some visa types for physicians. The J-1 is a specific carve-out that has a physician component, but they also do qualify potentially for an O-1 or an H-1B or other visa types.
Okay, cool. I have another question here from Steve in Australia. He says, I'm a software designer in Australia and would love to have a shot at Silicon Valley. I tend to do a lot of short-term contracts. Sorry, just one second. Would you recommend the E3 or the O1 for my situation? Would I need to get some kind of an agent?
Sure. So for the E3, there's some aspects of the E3 that make it difficult to work on a separate contract. You really would probably need to get a separate E3 to cover each independent contract. And the reason for that is that there are specific wage requirements that accompany the E3, that the sponsoring entity needs to agree to pay you the prevailing wage, and if that varies and you have various locations and different, arrangements in place and salary arrangements, payment arrangements, it could be difficult to make the E3 work. You might actually have to get one for each specific entity. There are potential workarounds in terms of using a visa to set up your own company and then booking the work through that company, but that's extremely circumstance specific to be able to determine whether that would work for you and what you want to do. And it's potentially possible on the E3, though there are some potential gray areas that you definitely want to talk to an immigration lawyer about. The O-1, in terms of giving you the ability to work on all these contracts with one visa in place, would probably be more practical because, again, the O-1 does permit for an agent to file for you, and then you can work for multiple entities through an arrangement with an agent as your sponsor. There are, again, specific logistics that are involved in that and specific agreements that need to be in place between the agent and potential contract employers and things like that. But theoretically, the O-1 would allow you to likely do it more easily in terms of being able to work for all those different contracts on one visa.
Okay, sounds good. Now, seeing as we had a question from Australia, we also have a caller from Australia. We've got Zoe Weatherall on the line. If you can unmute your line there, Zoe, if you're still on.
Hi.
You just want to go ahead and introduce yourself and tell us a bit about who you are?
Yeah, sure. So my name's Zoe. I'm from Melbourne, Australia. I'm a photographer. One of the questions I had, I am looking at like if I wanted to come to the US and work, say around January next year, when should I be contacting an immigration lawyer to kind of start the process? Like, should I be contacting someone now, or like how long does it take? And yeah, I guess that's my question.
Sure. This is Dana, and let me know if I cut out again, and then we'll just turn it over to Sarah. But while there are specific requirements about how early you can file an application, in some instances no more than 6 months before you intend to enter the U.S. or the employment is supposed to start up, in our opinion, it's never too early to start speaking to an immigration lawyer or other professional who's going to assist with this process, be it an agency like Stern Deeds or immigration counsel. That way you can set sort of what Sarah and I call our immigration plan in place, and that's talking about your immediate plans, identifying the best visa option for you, and then shifting gears to actually working on preparing and filing the case. And the amount of time that takes depends very much on the case. O-1 visas can be quite comprehensive and take longer to put together than perhaps an E3 visa, which can be very quick and you can apply directly at the U.S. consulate. But the short answer to your question is it really isn't too early to start this the process, at least the preliminary stages of having a consultation. And this is probably a rare suggestion from an immigration attorney, but we like to tell clients to talk to a couple of different lawyers and make sure that you work with someone who you feel comfortable with. This is an important process for you. It has long-term implications in terms of, the direction your career takes, et cetera. And you want to make sure that you have a partner in this process who can handle the legal side, but who also understands what you're trying to achieve and what your long-term goals are. So start now.
Okay, excellent. I do have one other question, if that's okay.
Sure.
So if I was to use like a company like Stern Deeds as my petitioner, and then if I was to get like a deal memo from another company to say they were going to give me work, is that enough to apply for the O-1 visa, or do I need multiple deal memos from different people, or is one enough?
So there's a couple elements there. So the O-1 visa is both forward-looking and backward-looking. So in terms of backward-looking, you have to obviously be able to document that you qualify as an individual of extraordinary ability by showing that you meet at least 3, but preferably more of the listed O-1 criteria, which are on USCIS's website. So backward-looking, that's really the most document-heavy part of the filing, is gathering the evidence to demonstrate your extraordinary ability, whether it be your portfolio or your letters from other experts in the field or other people you've worked with, your peers, speaking to your extraordinary ability, or reviews of your work, or awards that you've won, or grants that you've received. Things like that all need to be kind of packaged up and explained in detail to show how this evidence shows that you meet the regulatory criteria. So that's the backward-looking part. And in addition, you'll have to get letters from a labor organization or a trade organization or union in your field saying that they either support or do not object to you receiving the O-1 visa, and that's another important part, and also a time and cost consideration. And then the forward-looking part that the Immigration Service will want to see is that you have enough work lined up to cover the period of time you're requesting. So it really depends on what the deal memo says. If it's for one discrete project that lasts a few weeks, you're likely to only get the visa granted to cover the period of work you have lined up. So, multiple deal memos covering a longer period of time, the maximum amount of time you can request is 3 years, is ideal. But so it really depends on how much work and what period of time is covered in the deal memo.
Okay, so if I was to get a deal memo from a company that said something like they were going to give me like various different photography jobs over a period of 3 years, then in theory that would be enough.
Potentially, but again, the more abstract the work they have lined up, so that they don't have specific dates and specific things lined up, and how far apart the jobs are and things like that, it could potentially work. If you have something that lasts a week, 1 month.
Okay, I think we lost you there for a second. You still there?
I can finish Sarah's thoughts. I guess this is the value of having two of us on, and one technical issue, the other is just
tandem. Yeah, perfect.
Yeah, I think that what Sarah started to say is that it theoretically there's no requirement that you have multiple projects. So one long-term project lasting 3 years would in theory be sufficient to meet the regulatory requirements. But then there's that sort of added layer of review that USCIS is likely to do, which is look into how far apart the jobs are. So if they pushed and asked, for more specifics on the dates of the jobs, and it was one in January that was going to last a week, another in March that was 3 days, another in the summer, that might be problematic. And so you'd want to make sure that, it sort of passes muster. It's enough work to fill 3 years, not a week's worth of work spread out over 3 years, if that makes sense.
Yes, it does. Thank you.
Yeah, okay, because this is a very pertinent subject, and I'm really glad Zoe brought this up, because we have had a couple of other questions pertaining to this. So I'm just going to hit some of them. The first quick one, this one's from Liv Kirby from Australia. She's actually here in New York, and she's filed her O-1 petition 6 months ago and still hasn't had a decision. Do you have any idea what that would be and why that has happened? I guess it speaks to Zoe's question about having it timely and what have you, and you do hear about horror stories where things are held up and whatnot. I just sort of want to second straight away that there's never too early a thing, because you can't ever predict how long the USCIS is going to take to approve, requesting more information, or deny it. But just with regards to Liv and it taking beyond the 90 days, is there anything, any sort of explanation for why that's happening?
So, I don't know how much information Liv gave in her question, but I'll mention a couple of general points and then take a guess at what might be happening here. But Nimmers, you were absolutely right when you said there's really no predicting how long this process can take. O-1 visas can be filed pursuant to premium processing service, which is basically a fee-based expedite service that USCIS provides for certain applications. And the way it works is if you pay or your employer pays an additional $1,225 to USCIS. USCIS will adjudicate the petition within 15 calendar days. The problem with that, and why what Nimmers said is still correct, that you really can't predict what happens with the Immigration Service, is they can, within that 15-day allotment, either approve the petition, deny it outright, which is unlikely to occur because the third option is pretty common, which is they issue a request for evidence. And once they do that, and they usually do it on the 15th calendar day, the clock stops. You have to provide them whatever it is that they're asking for. Sometimes it's quick and you can turn it around relatively quickly. Sometimes they're asking for additional testimonial letters or things like that take several weeks to put together. So during that entire time while you're responding to the request for evidence, the clock is no longer ticking. Once you submit the response, they get a full 15 days to adjudicate, so really sort of doubling their adjudication time by virtue of having issued a request for evidence. The other option besides premium processing is filing pursuant to regular processing, and that's really anyone's guess. Stated USCIS processing times for the O-1 were quite recently saying that they were filed with regular processing, taking only a few weeks to be adjudicated. And in some instances, we saw that be true. However, we currently have a case that we filed in early June that's still pending. And because of that, we contacted USCIS on this issue, and they indicated that they're processing O-1 applications filed on or before April 2015. So in the case where someone has an application that's been pending for 6 months, I have to guess that perhaps they issued a request for evidence, and that factors in that time as well. It was certainly not filed with premium processing because that would be unheard of then. But my very strong recommendation to Liv would be to contact USCIS. There's a receipt number on every petition. It usually starts with either EAC or WAC followed by a series of numbers. And if you give them that number, they should be able to give you more information on the case. And if it is outside of their standard processing times, you can place what's called a service request with USCIS. And it's basically a way to try to sort of shake an application loose that may be sitting gathering dust on an officer's desk.
Oh, okay. I didn't know that you could.
And
yeah, okay.
Sorry, just to add to what Dana said, in addition to calling, if you just want to do a preliminary check, you can also go to USCIS's website, and there's a find or check my case status button you can go to, and then that you can type in that same receipt number, either the EAC or the WAC number there, and it should give you a quick, just a canned snapshot of where your case is in processing. So it's been received and it's being looked at, a request for evidence has been issued, things like that. So if you want to do a preliminary look there to see if maybe a request for evidence was issued and you never received it or something like that, that's always a good place to start before making a call.
Yeah, and I can just tell you that the number one issue our clients have is how long is this taking? You know, it's very difficult for us to sort of, we get that question all the time, how long does it take? And, you know, how soon should I do it? And, you know, overwhelmingly, people are frustrated with how long this process takes. And, you know, as someone who's trying to help them, it's very difficult for me to give them a straight answer because so much of it depends on the USCIS and their process and what have you. So, you know, the only advice we can give people out front here is, you know, is get it in as early as you can. You know, so you get the thing too early, great. Unless there's a massive project that you're about to do that's going to significantly sway your case, I'd say start yesterday. And you know, anything else you need to fill in, you're getting closer. But it's one of those things that however long you budget for, it'll take twice as long. And particularly if you have a hard start date that an employer needs you for a particular event, yeah, I think that you can never do it too early enough. And
I agree. sorry, Sarah, there are a lot of moving parts with the O-1 Nimmers, and this is probably also what you're talking about. So Sarah and I will oftentimes have clients who, want to expedite the process, both, have us prepare the application as fast as possible, which we're equipped to do, but then those moving parts come in, and USCIS is one that we talked about, but there's also an aspect of this where you're asking, 8 to 10 other highly regarded professionals in your field who know your work to sign off on, or in some cases, depending on the lawyer you're working with or the way the case is being prepared, draft, pretty strongly worded. And we always tell clients, getting someone to say yes is one obstacle, and the other is actually getting the signed letter back from them. And when someone's doing you a favor, you don't want to hound them and push them for the letter. So that sometimes, we always tell clients to allow additional time. There's always one straggler who went on vacation and forgot to sign the letter, and you're waiting an additional week, and so all of that can happen.
Exactly. No, that's right on the money.
The other thing is, just from personal experience, if you are trying to prepare this at any time in August and you're looking for letter writers predominantly from Europe, they're all on vacation, and about triples the return time to get letters back from them.
Yep.
Well, you bring up the question of Europe, and we have another question here from Andy in Italy. And here's an actor, and he says, I've acted in several movies here in both Germany and as well as English-speaking movies. My problem is deal memos, because I don't know anyone in the US who will hire me straight away. It seems to me like a chicken and the egg. I can't get into the US without a visa, and I can't do a job. I can't accept work without a visa. Is this? Let's talk specifically here about actors. Someone who is going to be, engaged, going to have to audition for a part. How would someone like Andy be able to sort of overcome this issue of the deal memos?
Sure. So again, it's not strictly an immigration question in terms of, how do you get contacts in your industry in the U.S. It's largely asking other people in your industry. It's networking. It's getting yourself, known there, meeting people who have contacts there, film companies that are both based in Europe and the U.S. It's about being creative and networking and getting yourself on those people's radars. There's no right or wrong way to kind of to do that in terms of, the immigration law says you can do X, Y, and Z. It's much more of an industry-specific question. Internet is a great resource here, Reels can be shared via the internet. You can reach out to people via email and contact them, things like that. But it does take some creativity because, unfortunately, one of the key components of the visa is having work lined up in the U.S. to justify the visa. And so certainly understanding the chicken or the egg situation that people feel that they end up being in when they're trying to pursue a career in the U.S. without having established contacts there. But unfortunately, it does take, talking to other people in your industry and getting yourself on the radars of the right people to help get that in place.
I have a question that relates to that, actually. I have heard that if you get a deal memo from someone and then once you have the visa and you're in the country, that if that falls through for any reason and then you end up working for other people, that's actually okay. And if you were to get someone to write a deal memo and then not actually work for them, is that something that people can do to get around that situation?
So am I sounding choppy? Because I understood the question, but I just want to make sure people can hear me clearly.
No, we got you loud and clear. I do.
Okay, great. Yeah. Okay, wonderful. So it is true that changes to an itinerary once you are in the U.S. and you've gotten the O-1, so you had 5 things lined up, 1 fell through, 2 more came into place, all within your industry, all within the scope of what your extraordinary ability is. Those don't require amendments to your O-1 petition. Having more work lined up within the scope of what we've classified your extraordinary ability in doesn't require amending or filing a new O-1 every time you get a new job lined up, if you filed it such that you have an agent sponsor and you're not having just an employer sponsor you, because there's different ways the O-1 can be filed, and when you have an agent sponsoring you, again, it allows you to have multiple different jobs lined up for different companies, and everything is kind of captured through the agent representing you in some aspects, either before the immigration service or as a more traditional agent. There are different ways it can be structured. But the other way O-1s work, which is much less common for creative people, is that employer A sponsors you for a visa. You come in on that visa for employer A, and you are only allowed to work for employer A. And then employer B wants to hire you. In that case, employer B needs to file a new O-1 for you because it hasn't been structured as an agent with an itinerary. You've only been permitted to come and work for your single employer sponsor. So it does depend on how the O-1 is structured, whether through an agent or something. And just because employer B needs to sponsor you for a visa doesn't mean that you can't continue to work for employer A. You can hold concurrent O-1 visas. It just means when a new filing is required really depends on how the petition was initially structured.
Zoe, did that answer your question? Yep.
Yes, it did. Thank you.
Okay, cool. So I want to give Helen a chance here. I didn't mean to hold you back there, but are you still on the line there, Helen?
Yes, I am. I'm just listening. Sorry, I had my headphones on.
No.
Thanks very much for all the info you provided us with. I guess my questions are, so I am a visual artist. However, I'm not really exhibiting anymore. Instead, I'm creating sustainable programs in Canada, specifically on First Nation reserves. So I'm just wondering, is there any way that I can transfer my visual arts background in order to continue to do programs with marginalized people in New York?
It's a pretty big question to ask without knowing more details about what you do. A lot of times after examining someone's case and, trying to find a nexus between what their background is and what they want to do, it is possible to find some common threads that show how your skills are continuing to be utilized to justify kind of this new related area you're going into, but it really would require a very case-specific analysis to look at your background and the specifics of what you want to do and see if we can make that nexus to make a visa work for it.
Right.
For instance, sorry, Helen, go ahead.
Oh, no, I was going to say, should I perhaps maybe make a meeting with someone and speak with someone on-one?
Yeah, I think Nimmers mentioned this at the start of the call, and I promise everyone on the line that this is not a plug to have you arrange for consultations with us. As I said, I like clients to shop around. There are a ton of immigration lawyers out there, and you have to find one that's a good fit for you. This is meant more of a sort of get the conversation started and provide people with enough knowledge to ask the right questions and know sort of what they want to hone in on when they do speak with a lawyer who can provide legal advice specific to their case. So what I started to say, Helen, was, for example, what we would do in a case like yours is have you provide us with sort of your visual artist portfolio, what you've done, where you've exhibited, sort of the straightforward, here's Helen on paper and what we could provide the immigration service about your accolades, et cetera, as they relate to that. And then have you provide us with an understanding of what it is that you have an opportunity to do in the U.S. or want to do in the U.S., and as Sarah said, try to find a nexus between them. So if you were, working with underserved populations to sort of beautify playgrounds in schools, and there was a component of that used sort of your art background, but you're doing it in sort of an urban setting, that could be workable. But yes, to answer your question, our recommendation would be that you set up a consultation with an immigration lawyer and talk through this.
Okay, excellent. Thank you.
You're very welcome.
Yeah, no, that's another good point there about the job title that you want to come to. And often, particularly people in the arts will sort of go through different stages in their career. And they absolutely want to try and leverage some of their early experience to state their claim. But a lot of it comes down to what is the job title that you're you're going for. I mean, in my profession, I might be working as an editor. I might have an opportunity to be a producer. As far as immigration is concerned, they're looking for someone who's exceptional in a certain job title, and that you'll be applying something in that field at least, or something related to that. So I know particularly people in the arts who are doing lots of different things and wear many different hats. And, you know, arguably James was sort of saying how he does a little bit of both. I think, you know, working with a lawyer and finding what I call a job title that sort of suits what you're trying to do is a really important first step in all of this.
And just to kind of add to that, a lot of times we'll use people's kind of expertise in related but slightly different industries to point out what makes them unique. It actually narrows the field. You know, there may be a lot of producers and a lot of directors out there, but there's very few who have this hybrid experience that allows them to have this unique skill set that actually sets them apart from others in their field. So sometimes it can be used as a strength to kind of show how someone either is more unique in a more narrow field or has made original contributions to their field.
Exactly, and sorry, if I can just piggyback on that as well. You know, when you are talking to a lawyer, you know, we recommend you just lay everything out on the table there. You know, even things that you might not think were all that relevant, you know, in the scope of things, might actually be pieces of evidence that will support your case. Yeah, you might have worked with someone 20 years ago who, you know, you played a small role, but if that person's gone on to do something significant, and you know, you can somehow be connected to that. All these different, I've heard many cases of people saying, oh, I started this, I told them that, and then, well, why didn't you tell me about this other thing? I can definitely use that. I'd recommend, you know, when you're providing a CV to a lawyer, put everything in there. And, you know, if there is a way to, you know, use one experience to strengthen another, I think that can really help your case.
Yeah, absolutely, Nimmers. We tell all our clients that the O-1 is not an exercise in humility. So this is not the time for you to downplay a role or a project or an award. You have to sort of, you know, give us everything, lay it all out there, and, you know, even the most minor achievements, you know, can help bolster a case. So keep that in mind.
Okay, great. Thank you.
Okay, so I have just one or two other emailed in questions, and then we'll sort of just to wrap it up, I'll give everyone a chance just to jump in and just see anything more general. I've got a question from Pedro here in Brazil. Do I need to bring my petition with me to my visa appointment when I get my visa stamp?
So that's actually a good question. So the general rule is that when you file these petitions, you file them in duplicate, and upon approval, the duplicate copy gets forwarded to the consulate through an internal system called PINS. So they should have a copy on file. That being said, we do generally encourage people to bring it in the event that there's a glitch in PINS, they can't pull it up, there's some item that they require verification on. And I do have a story of a very prominent gallery director who was going to pick up her O-1 visa stamp in Paris, and she did not want to bring her petition with her because it was quite large, and she decided not to, and the consular officer basically said something to the effect of, I'm too lazy to pull this up in the system, refused to issue her the visa, and she had to reschedule her appointment and come back with a copy of the petition. So that is absolutely a worst-case scenario. Some consular officers don't even care to see it. But you know, there are those outliers who will want it, who can't pull it up in the system, want to see it in hard copy. So it's always best to just, you know, be safe and bring it, and that's generally what we advise our clients to do.
Okay, it's not the end of the world, but it's definitely another setback of a little while and another expense and what have you.
Yeah, it's more just a logistical problem. It's not that anything got denied. She's here on her O-1 now and everything's fine. It was more just having to reschedule her travel and things like that.
Okay, so I've got a quick one here from Carlos from Ecuador. I am in New York and I'm starting my career as a videographer, but I'm not quite at the O-1 level yet. What other options do I have? I've heard about the J1 and the P1 visas, but I don't know much about them.
So this is one of our favorite questions, because Sarah and I have spoken at some universities and graduate schools, and we talk to a lot of students who have a similar question. I'm not yet at the O-1 level, and then there's really two parts to it. One is, what are my other options? And then that's sort of your alphabet soup. There are a number of visas that can fit depending on what it is that you want to do. Some have some potential downsides like the J1, and I can talk about that. Some have potential hurdles, such as the H-1B, which even if you could make the case that it's a professional position, one that requires attainment of a bachelor's degree in a specific field, H-1B visas are in such high demand and short supply that basically they're only available one time a year, and even then it's a lottery. So even if you file on the very first filing day, which is April 1, there's no guarantee that your application will even get selected for adjudication, let alone approval. So, there are some potential downsides. The other part of the question, and the part that we like to talk about, is what you can do to sort of bolster your CV. And there are a lot of things that you can do that people should start thinking about. Accepting speaking engagements at your, maybe the school where you graduated from, or serving as a mentor for students in videography school and things like that. So always be thinking about that, maybe parallel to talking about your other visa options. The options for someone specifically from Ecuador would be limited in certain regards. Sarah mentioned earlier that our lucky Australian callers have an E3 visa that is open to them. Canadians have the TN, Mexicans as well. There's no specific carve-out of visas for Ecuadorian nationals, but they do have a treaty that would allow them to apply for an E-visa. And that's something that I think is worth the questioner looking into. There are some limitations. And the J visa is another good option, but it's sort of, in our view, the polar opposite of the O-1. So the O-1 is extraordinary ability. The J-1 is typically used for someone who's taking an internship or a traineeship in the U.S. So sometimes hard to leverage a J-1 into an O-1, but not impossible. And the other thing you always want to check out before coming to the U.S. on a J-1 is whether it's going to subject you to a 2-year foreign residence requirement. And I won't go into too much detail, but in certain circumstances, depending on the country you're from and what it is that you're coming in to do, you may have to have a requirement that you have to return to your home country or a country of permanent residence for 2 years. And there are some waivers available and some exceptions, including some exceptions surrounding the O-1, but it's a little nuanced. So just look out for that if you're considering a J-1.
Okay. And we did have a question specific about the P visa. This is Paula from Sweden. She hosts a New York City, This Week in New York City show on the web in Swedish. Is that considered as a culturally specific event where she might be able to apply for a P visa?
So it would really depend on the content of the show, and it's a bit of we'd need more information to determine whether it would qualify as being a culturally affiliated enough to qualify. But the fact that it is in Swedish and it's the content is largely about Sweden or things to do with Swedish culture, it's possible, but definitely something you need to look into in more detail with an immigration lawyer.
Okay, great. So I sort of now want to open it back up to anybody else who's on the line here. You can feel free to go ahead and unmute yourself. And I just want to make sure that everyone who has dialed in has had a chance to maybe ask a follow-up question or get you just for the last 10 minutes while we've got you here. Does anyone just want to jump ahead with this?
I have one.
Go for it.
So my South African passport, which I'll be applying on, expires in 2017. Should I be renewing that passport now, or can I still go ahead with it?
So there would be no barrier to you getting a visa stamp. Can you just remind what date did you say it expired in?
2017.
So yes, the only requirement for getting a visa stamp inside is that you have at least 6 months of validity remaining on your passport, and you have 2 consecutively blank pages inside. If you do get an O-1 visa stamp and the stamp is valid past 2017, essentially what will happen is you'll have to apply for a new passport once that one expires, and then you'll just travel with 2 passports until you end up needing a new O-1 visa. They generally don't let you just get a new O-1 visa because you got a new passport. You just have to travel with 2 passports. The only other thing to be mindful of is that if you are coming in on an O-1, and let's say the O-1 is valid through 2018, but your passport expires in 2017, when you clear immigration at the airport, they do have the discretion to admit you only through the expiry of your passport. So you always want to check that to make sure you know how long you're actually permitted to be in the U.S. for. If it's not always the expiry of your visa, it could be the expiry of your passport. So because of those complications, and you have a bunch of different dates that you need to be monitoring, it may be the best practice to just get a new passport if you do anticipate asking for a visa that the duration would be longer than the validity of your current passport.
Okay, great. And then I'm going to be, I've got some different deal members coming from different cities. So I have one in San Francisco and one in LA. Does that make any difference?
In terms of? Sorry, go ahead.
Oh no, and just in terms of having deal members from different people, from different potential employers.
No,
so
okay.
I mean, the nature of my job is that I travel. So
as I was saying earlier, it depends on how your O-1 is structured. If it's structured through an agent, then the expectation is that you will have multiple jobs lined up, and they will likely be in different locations. This should need to be identified on the itinerary. So it isn't per se a problem, but again, it depends on how the O-1 is structured.
Okay, great.
What about Zoe or Helen there? Do you guys have any other final questions or anything to add?
I just have one question. If you have a sponsor, like as an agent, what exactly does that mean once you get the visa and you're in the country? Like, do all your jobs have to be paid through the agent, or is it sort of more of the visa process, and once you're in the country it doesn't really mean as much? Or
So I'll let Nimmers speak to this a little bit too, but generally there's different ways in which an agent can serve as your sponsor. That can be an agent acting as an employer, an agent acting on behalf of an employer, things like that. So there's no bright line test for what elements need to be in place for someone to be properly acting as your agent. Obviously, having payments booked through your agent is strong indicia that the person has the authorization to be acting as an agent for purposes of the petition, but that's not the only way. I think that the general rule is that you have to show that you've at least relinquished, the agent has at least some power or some control or some exclusivity over your work in the U.S. But that doesn't necessarily mean that you have to be paid through them or everything has to be booked through them. There's different ways that can be structured. And again, there's about 4 or 5 different ways that an agent sponsor can be structured, and the evidence you need to present in terms of how the beneficiary is related to the agent really depends on exactly what type of an agent they're serving as.
Okay, cool. Thank you.
No, nice one. Some great questions, and I really feel like they really do in many ways sum up a lot of the questions we get every day. Sometimes most often it's about how long, how much, what can I do? But then once we sort of scrape the surface about what's involved in this, a lot of these questions that are coming up are really quite typical. So I really appreciate you guys taking the time out to answer these questions.
Oh, absolutely, our pleasure, and thanks to the callers. The questions, as Nimmers said, were definitely relevant, and as I think we mentioned, touched upon things that our clients are seeing each and every day, adjudication delays, deal memos, et cetera. So they were really relevant questions.
Cool. And again, guys, if you guys want to get in touch with DNS, immigration, they've got a website here, and we've also got their Facebook page here. They're always putting up different, notes and different postings about the immigration. So it's always good to sort of keep in the loop there of what's happening with other people and where other applications are at. But, really, thanks so much for being on the call here. If anyone's watching this on the YouTube channel, feel free to leave comments below, and, we'll try and get to them when we can. Anything else you guys like to say?
No. I just wanted to thank Sarah and Dana for participating. Thanks so much. And thanks to everyone for calling up with your questions.
Thanks, Lauren. Okay, cool. She's been a little bit quiet, so don't be shocked if she jumped in like that.
I had some questions to ask, but they just got covered by everyone. So I'm like, all right, excellent.
Cool. All right. So I guess we're just going to wrap it up there. Say goodbye, and we'll just end the recording right here. Thanks.
Thanks, everyone. Bye-bye.
Thanks,
everyone. Bye.